Welcome to Environmental Law course, dear learner and viewer. In continuation to our previous lecture on the common law remedies for environment protection in relation to law of public nuisance in colonial India and independent India, we will be looking at the case law development and case law roundup on the public nuisance law in India to give a kind of a concluding point to our discussion on law of public nuisance. The reason happens to be that the case law development on public nuisance law is one of the most emerging areas, and there is a constant flow and the sufficient flow of the case law in relation to public nuisance laws. It's a different thing that the ratio and the arbiter of the municipal council Ratlam versus Verdichan was something very novel and epoch-making and landmark, and never before we have seen the teleological interpretation of public nuisance law, especially the section 268 and in the Indian Penal Code, and as well as section 133 CRPC, vis-a-vis the Constitution of India's mandate under Article 38, 39 and 47 of the Indian Constitution. The kind of the novel jurisprudence which has been built upon and around the municipal council Ratlam versus Verdichan, and as it has been viewed by the various scholars in America and the UK, and quoting Rosencrantz and as well as the Michael Anderson, that how the public nuisance laws, which was a classical pointer to the colonial piece of law in this country, have not seen such a very vital and potential application as it has been the case of the Municipal Council Ratlam versus Verdichan, handed down by Justice V.R. Krishna Iyer and O. Chinnappa Reddy in 1980. It tries to chart out a different course to let down the jurisprudence of the environment and as well as the sanitation, health, and public tranquility. In continuation to the discussion about the law of public nuisance in colonial India, independent India, by perusing all the relevant provisions and the landmark judgment on Municipal Council Ratlam versus Verdichan, we'll be taking a cursory and a broad look at the case law development on public nuisance in independent India. In this lecture, what we will try to see that how environmental problem as public nuisance within the classical and doctrinal limits of the common law remedies can be fitted into, despite the fact that India can boast to have a range of sophisticated environmental laws. Nonetheless, the relevance and the legitimacy of the common law remedies still holds the ground, and it creates a different and unique course of action. The unique course of action is being charted simply because that the environmental problem as public nuisance, which has been addressed under section 268 of Indian Penal Code and as well as section 133C Criminal Procedure Code 1973, is unique in the sense, as Professor Upendra Bakshi in a small booklet, Environment Protection Act, an Agenda for Implementation, when this act was passed and it was debated in the backdrop of the Bhopal gas tragedy, then he very succinctly remarked that the same act, when the Environment Protection Act 1986 was passed, in the same act Consumer Protection Act was also passed, but we do not find, as the Consumer Protection has three-tier mechanism, the Environment Protection has two-tier mechanism, meaning thereby we have a Central Pollution Control Board and a State Pollution Control Board, wherein in the Consumer Protection Act we had the District Consumer Forum, we have a State Consumer Commission, and we have a National Commission on Consumer. This is a very pithy observation of Professor Upendra Bakshi in the sense, and I am quoting here for a valid reason, that environmental problem which has been perceived as a public nuisance law And I am referring time and again to Section 133 CRPC. Supposing there is no district pollution control board available, and then even if we have very salutary laws on the environment, water, air, then most of the environmental problems and which are associated, which is very widespread and can be declared as a public nuisance, can be fitted into the public nuisance, where the person and public and people in large can bestow and repose confidence in magistrates' power, because the magistracy is in district. And since we do not have a kind of a mechanism at the District Pollution Control Board, each and everywhere in the country, in some of the metropolitan areas and in some states, we have District Pollution Control Committee or board, not the board but committee we have, then that desideratum and that gap which has been envisaged into the Environment Protection Act, Water Act, Air Act can be filled by Section 33 CRPC. And as we have realized in Ratlam case, that the power and functions of the removal of the public nuisance given to the magistrate appears to be discretionary, but assume the character of mandatory import when there are circumstances which justify for immediate removal in case of the wide scale of environmental degradations and environmental pollution and insanitary conditions. Therefore, environment problem as a public nuisance is still very, very relevant in the aftermath, and that too taking recourse to the salutary impact of the judgment of Municipal Council Ratlam versus Verdichan. Although after the Municipal Council Ratlam, there has been a catena of the cases which has been decided on the law of public nuisance, which have given various facets and dimensions, and try to see that a wider angle of the Section 133 CRPC is being identified by these cases, meaning thereby it does not look Section 133 CRPC, the cases to be discussed and to be followed now, gives a very widest amplitude of Section 133 CRPC, and that widest amplitude is beyond the pale and pounds of Section 268 of IPC, and that is to be seen in the light of the case law. Then we will be having a kind of a critical assessment, and we will try to evaluate that how the criminal law analogy for protection of environment, especially the law of public nuisance, as well as Section 133 CRPC, will go a long way or it will go to a short way and have certain inherent shortcomings to every now and then applying the doses of criminality into the matters of the environmental pollution control, and what is its far-reaching consequences and what happens to be its far-reaching promises and pitfalls of having a kind of a sanctioning regime, having a kind of a control and command regime, having the efficacy and effectiveness of the fines, and then we will try to see the limitation of criminal prosecutions in applying the water law, air law, and the environment law vis-a-vis the environmental problems and the nuisance under the cabin and caption of the law of public nuisance. Having this critical assessment to see the relative advantages and disadvantages of the common law approach, which remain still very germane and relevant, we will try to have a very dispassionate look into the very interplay of the criminal sanctions and enforcement. With this, we will try to see that how Environment Act, how the theoretical and practical limitations of the criminal law, how the no-fault theory, how the mens rea theory, how the strict liability theory, and how in the jurisdictions, foreign jurisdictions, they have created penalties, imprisonment, and the penal regime for environment protection, and then they are switching over to different kind of a mechanism and exploring ways and means to a more viable and effective methods of the environmental control. Will be just hinting on touching and flagging those issues in the conclusion of this lecture, which happens to be the last lecture on the common law remedies for environment protection in relation to public nuisance law, especially tracing the case law development after the Municipal Council Ratlam versus Verdichan, and to see that how Section 133 CRPC's one version, which is close-circuited to Section 268 of IPC, and Section 133 CRPC's another version, which is close-circuited to the water law and air law and the environment law. That has to be seen in this lecture and to be discussed in a very candid manner. Let's begin with the legislative enforcement and the case law roundup. For the sake of reiteration, again, the public nuisance law, which is there in the 268, and then we will see that what has been permeated in 290, having a fine of rupees 200 in 1860, and then we will see that how the interface of Section 268 of law of public nuisance, which talks about injury, annoyance, danger, and obstruction. So, injury, annoyance, obstruction, and danger to whom? One who are having property, one who are having a public right under 268 of the Indian Penal Code is being safeguarded and how the criminal prosecution for causing public nuisance and its procedural counterpart of Section 133, which extend beyond to Section 144, and how side by side a replica of it in the civil action contained under Section 19(1) of the CPC, which always try to see a similar kind of the civil kind of a remedy, have a comparative advantages in containing environmental problem as public nuisance. We will also see that how the ratio and obiter dicta, ratio doesn't die, and the obiter dicta of the Municipal Council Ratlam has been a guiding force in cases which have already been earmarked in Tata Tea case, in Modi Distillery case, in Mohan Meekin's case, along with the cases on the point Gobind Singh versus Shanti Swarup, P.C. Cherian versus State of Kerala, Ajit Mehta versus State of Rajasthan, and K. Ramachandra Mayu versus District Magistrate, and how Section 133 CRPC, as I have explained in the earlier, is not to be seen alone from the lens of text Section 268 of IPC, and now we try to see from the prism of Air Act and as well as the Water Act, and we'll try to see that the magistracy's power under Section 133 CRPC, how it clashes, or the power of the magistrate happens to be in addition to, or it is in, there are two questions. The one, the power of Section 133 CRPC is in addition to or in derogation to pari materia incorporation of Section 133 CRPC in the Water Act and the Air Act, in matters of search and seizure, in matters of closure of industry, in matters of stoppage of supply and raw materials. So, is it not the replica of the Section 133 CRPC, where the magistrate has the power? Here the Central Pollution Control Board and the State Pollution Control Board has the power, and the nature and content, ambit and scope of both the power tantamount to what is called is very analogous, as it has been heavily seated in the Air Act and the Water Act, and as well as the Environment Protection Act. So, conditional removal of the public nuisance under 133 CRPC and the removal of the air pollution and the removal of the water pollution will go alongside or independent or concurrent, and these powers of the Central Pollution Control Board and the magistrate are in addition to or in derogation to. That kind of the clash will be looking at in the light of these cases. In Tata Tea Limited versus the state of Kerala in 1984, the Kerala High Court held that Water Prevention and Control of Pollution Act impliedly repealed Section 133 CRPC. Therefore, the Kerala High Court was of the view that this is a separate kind of a remedy and it is essentially linked to Section 268 of IPC alone. And then magistrate has no jurisdiction. Why? Because it has already created a pollution control board. So that question was answered in Tata Tea versus State of Kerala, that it does not have a coexistence and coextensive application, but it has impliedly repealed Section 133 CRPC in cases of fouling of water, pollution of water as a matter of law of public nuisance. In a later case, UP Pollution Control Board versus Modi Distillery in 1988, decided by the Supreme Court, the company was discharging water into Hindon River in violation of Section 25 and 26 of the Water Prevention and Control of Pollution Act 1974. And then court criticized that the technical lapses have resulted into a menacing level of pollution and the company wanted to avoid its liability. Then the liability which has been fixed under Section 47 of the Water Act was also applied into it. Now here again the question was that if Central Pollution Control Board or the State Pollution Control Board or the UP Pollution Control Board is not acting in right earnest, is it advisable that Section 133 CRPC can be applied in relation to the violation of Section 25 and 26 of the Water Act, Section 25, Section 26 and Section 47 of the Water Act? Therefore, what we see that in these cases, there is the opinion of the judiciary is at variance. In a similar case in Mahmood Ali versus State of Bihar, where not punishing from a criminal point of view, but the managing director were presumed to be liable about their negligence, and if they have a proof, lack of knowledge or due diligence, then in all cases of water pollution, it can be applicable. In another case known as N.A. Palkiwala versus MP Pardushan Nivaran Mandal, a sense of limited liability has been imposed under Section 133 CRPC in cases of pollution. Then this is another case which have, as we have the case of Tata Tea, in relation to the interplay of the Water Act with that of Section 133 CRPC, we have a case of Abdul Hamid versus Gwalior Ran Silk Manufacturing Company Limited, 1989, Criminal Law General 2013. In this case, the MP High Court held that the Water and Air Act are complete codes of industrial pollution, and therefore Section 133 CRPC jurisdiction stands repealed by application for matters covered by the special code. So, while in applying the general criminal law and while applying a specific law on the point, the precedence should be given to a specialized law, be that water, be that air, than that of the criminal law, was the ratio of the Abdul Hamid versus Gwalior Ran Silk Manufacturing Company Limited in 1989. Then in a subsequent cases, what has been let down in Tata Tea, what has been let down in UP Pollution Control Board, because the UP Pollution Control Board versus Modi Distillery is a judgment by Justice P.N. Bhagwati, and this judgment is also very important, where Justice P.N. Bhagwati expressed dismay and displeasure that how companies like Modi Distillery, which is a reputed company, is not coming to the terms of Section 25 and 26 and 47 of the Water Act. Once it's not complying to Section 25 and 26 of the Water Act, then the corporate liability for environmental pollution, as it has been let down under offences by the companies, Justice P.N. Bhagwati have been very candid to impose a criminal liability, as that criminal liability has been visited into Section 14, which fixes the liability of corporation, offences by the corporations, offences by the government. So, it was considered a kind of an offence. So, some sense of criminality has been imposed by Justice P.N. Bhagwati in the case of UP Pollution Control Board versus Modi Distillery in 1988, meaning thereby the judgment of the Modi Distillery by Chief Justice P.N. Bhagwati have not overruled the application of Section 133 CRPC. Rather, it has very silently and very intelligently, without dwelling on the controversies of the clash and congruence of the pari-materia incorporation of Section 133 CRPC into Water Act, Air Act and Environment Act, it switched over to impose corporate liability for the environmental pollution in case of Modi Distillery. So that way it will not be very fair to say that Modi Distillery has avoided the question of the application of Section 133 CRPC in relation to Section 25 and 26 of the Water Act, because it has at least made the violation of Section 25 and 26 of the Water Act with attaching some criminality and some fixing some liability on the corporate officials on the basis of deeming fiction in matters of water pollution in the Hinder River. Now, the case in point, that the two cases which we discussed, Abdul Hamid Tata Tea Limited versus State of Kerala, 1984, the Kerala High Court decision, and then Abdul Hamid versus Gwalior Ran Silk Manufacturing Company Limited, 1989. As these two cases have categorically ruled out the application of Section 133 CRPC by indulging into a kind of a discussion that inconsistencies of the generalized and specialized law can be resolved by giving precedence to a special environmental statute. The case in point, Harihar Polyfiber versus Subdivisional Magistrate 1997 Criminal Law Journal 2731 is a decision by Karnataka High Court, and wherein the Karnataka High Court held and have balanced the jurisprudence and the controversies and the confusion which is being compounded by Tata Tea and Abdul Hamid, or we can say the Tata Tea case or the Gwalior Rayan Silk Manufacturing Company Limited case vis-a-vis the Modi Distilleries case is being dispelled by laying down that Section 133 CRPC is still valid. And this is the moot point which we are going to impress upon, that in the aftermath of Municipal Council Ratlam versus Verdi Chand, as it has been expected and as it has been offered by the criticism of Armin Rosenkranz, that seemingly dull legislation of 268 of IPC and Section 133 CRPC in matters of environment and its application, it was underutilized, it was dull, it was never thought to possess such a vast potentiality as it has been displayed and portrayed in case of Municipal Council Ratlam versus Verdi Chand. And then the expectations were running very high. Even we take the critique of Michael Anderson about the public nuisance law and the private profit and the colonial interpretation of the public nuisance law right from 1860 to 1980 till the pronouncement and delivery of Municipal Council Ratlam versus Verdi Chand. Michael Anderson was of the also view that never before in the entire historical annal the law of public nuisance have been so vociferous in articulating right to environment, right to health, right to sanitation, and casting uncompromising and indelible liability on the municipal corporation and as well as the magistrate at the district headquarters by as laid down under Section 133 CRPC seems to have a revisit in Harihar Polyfibers versus Subdivisional Magistrate in 1997, which has categorically underlined that Section 133 CRPC is still valid for emergency environmental situations, meaning thereby that the common law remedy for environment protection through the vehicle of the public nuisance law is independent and autonomous, is in addition to whatever remedies have been provided in the Water Act, Air Act and Environment Act by pari materia incorporating the spirit and essence of Section 133 CRPC to bring the defaulting and polluting industries to the task, still hold the ground. And the Karnataka High Court in Harihar Polyfiber versus Subdivisional Magistrate have rightly laid down that the Pollution Control Board follow lengthy procedure and then magistrate has a summary procedure. So, lengthy procedure versus summary procedure which has been laid down under Section 133 CRPC has a far-reaching implication and it creates an immediate remedial measures In a subsequent case, that we find that the doctrine of implied repeal, the Karnataka High Court in a very unmistakable term has ruled out the doctrine of implied repeal by virtue of the Water Act, Air Act and the Environment Protection Act. The one is 1974, another is 1981, another is 1986. So, these modern set of law of water, air and environment, and the confusion which has been compounded by Gwalior Rai and Silk Manufacturing Company Limited and as well as the Tata Tea Limited, that confusion is being completely dispelled by the pronouncement of Harihar Polyfiber case by the Karnataka High Court in 1997, and it finds there is no direct conflict between these two provisions. One requires the board's provision is lengthy provisions, magistrate's provision is summary provision. It has taken a comparative advantages of both the provision and it see great merit in immediate remedial measures for removal of the environmental pollution, and it also take into account that there is no conflict, both exist independently. In a subsequent case of Nagarjuna Paper Mills Limited versus Sub-Divisional Magistrate 1987, the Andhra Pradesh High Court reaffirmed the application of Section 133 CRPC in the water, and it says that it remains the Water Act have an analogous provision under Section 33A and many other provisions, but it remains totally unaffected. Therefore, the prior sanction requirement under Air and Water Act does not eliminate magistrate jurisdiction, because the magistrate jurisdiction under Section 133 CRPC is having a sweeping power and that is not going to be affected by any kind of an environmental statute. Then we see the cases relating to the public nuisance under the Mohan Meekins Limited case in 2000 and as well as Pulgaon Cotton Mills, wherein the court held that this case is very important, that right from Section 24, 43 and 47 of the Water Act, which have made directors vicariously liable for the offences committed by the company in Mohan Meekins' case, will go a long way in bringing the errant and defaulting industries to the task and at the same time giving extent to Section 133 CRPC the power of the magistrate. So much so, the cases which has been followed by the Harihar Polyfiber and Nagarjuna Paper Mills Limited after the Mohan Meekins case having a corporate liability, then in Pulgaon Cotton Mills also a very novel finding was to see Section 197 CRPC is required to prosecute officials of the government companies as it has been envisaged in the Criminal Procedure Code, or Water Act has a direct provision or prior sanction requirement under the Air and Water Act does not eliminate magistrate jurisdiction under Section 133 CRPC as it was triggered in Nagarjuna Paper Mills case, was slightly raised in a different tone in Pulgaon Cotton Mills case, and then we see that in our assessment and outcome that the common law remedies for environment protection through the lens of public nuisance law in colonial, independent, contemporary India and after the pronouncement of Municipal Council Ratlam's case, the catena of the cases which we pursued to buttress the point that the relevance of the Section 133 CRP and Section 268 of the IPC and Section 33 CRPC, is an autonomous entity and existence and legitimacy as it has been established in Govind Singh's versus Santu Saroop, PC Cherian versus State of Kerala, Ajit Mehta versus State of Rajasthan, K. Ramachandra Maya versus District Magistrate, Tata Tea Limited versus State of Kerala, UP Pollution Control Board versus Modi Distillery, Abdul Hamid versus Gwalior Rayan Silk Manufacturing Company Limited, Harrier Polyfibers versus Subdivisional Magistrate, and Nagarjuna Paper Mills Limited, along with the UP Pollution Control Board versus Mohan Meekins and Pulgaon Cotton Mills versus Maharashtra Pollution Control Board. As a concluding part, we can say that the gradual relevance and revival of the criminal sanctions which has been imposed under the common law remedies for environment protection, especially the public nuisance law, still holds ground even after the sophistication of large number of the environmental statute, and that's why we still adduce great respect and reverence and relevance to common law remedies for environment protection, especially the public nuisance law, in substantive and procedural manner as an independent law and also as in the environmental statute. And thus, my dear learner and viewer, this concludes the entire discussion on the common law remedies for environment protection. Thanks and happy learning.